Yeah, I need her out of my house. That's where I live. I have no other place to live, so I can't pay for two dwellings. I gave her, it's been 30 days now almost, so.
Ms. Campbell, what is your response?
Well, my response is that I have the five children here with me, and I have I have been unemployed for the past 7 years, and it's really difficult for me to find a house for six people over within even 30 days. And I'm just wondering if the court would give me an additional 90 days. And I'm working with different housing agencies.
Well, that,
A man who owns his home is sleeping on his mother's couch. The woman living in his house, the mother of his 5 children, has just stood up in court and asked for 90 more days. And here is the question that will hang over this entire case if she has no lease, no title, and no legal agreement of any kind. What exactly gives her the right to stay there at all? Stick with me, because the answer is more complicated than you think, and it reveals a gap in the law that could affect anyone watching this video right now. This is a real eviction hearing. No famous defendant, no high-powered attorneys, no cameras except the court's own recording system. What it has instead is something rarer and more instructive, an ordinary family dispute that strips away every distraction and shows you exactly how property law works when two unmarried people, 5 children, and 1 house collide in a courtroom.
Mr. Howe, have you gotten proper proof of service on Ms. Campbell?
yeah, I do.
I don't, however, I don't see it in the court file. You have a copy of it with you?
Yeah,
You need to send it into the court so I know that you have proper proof of service. If you do that, I would appreciate it. Ms. Campbell is here today, and I saw both of you in court earlier today. I won't go through all of that, but so I know that you're aware of what's going on. Is there an agreement that the parties can reach as to how to resolve this portion of the disputes?
Mr. Howe owns the house. Miss Campbell lives in it. He is asking her to leave, and the judge is about to explain, with patience and precision, why the law is not as simple as he clearly hoped it would be. I'm sleeping on my mom's couch here, and I'm about to have to pay for another residence. That sentence, delivered in open court on June 8th, is the emotional center of this case. Mr. Howe has been out of his own home for roughly 30 days. He served Miss Campbell with a notice to vacate, a formal legal demand to leave the property, first by mail on May 14th, then personally May 29th. He followed the rules. He did what the system asks you to do. And now he is standing in front of a judge explaining that he cannot afford to pay for 2 places to live, while the legal process grinds forward. Of Miss Campbell's response is the part that will make half the people watching this furious and the other half genuinely sympathetic.
Well, my response is that I have the five children here with me, and I have been unemployed for the past 7 years, and it's really difficult for me to find a house for six people over within even 30 days. And I'm just wondering if the court would give me an additional 90 days. And I'm working with different housing agencies.
She has 5 children. She has been unemployed for 7 years. Finding housing for 6 people in 30 days, she tells the judge, is genuinely difficult, and she is working with housing agencies to try to find something. She asks for 90 more days. The judge cuts her off before she can finish the thought. That, he says, cannot happen. But here is where it gets procedurally interesting. And this is the part most people watching a clip of this hearing will miss entirely. Before the judge can rule on anything, he has to ask a question that seems mundane, but is actually the hinge on which this entire timeline turns.
Was Ms. Campbell served?
it looks like on the 14th, May 14th.
All right. Typically, she has, was she served personally or by mail?
By mail. But that was a 7-day one, and then I think she was served again. I sent her another one that was a 30-day notice.
She was personally served. It was 5/29. The
Right.
notice was just for a hearing.
Typically, if she's personally served, she has 21 days to respond to the allegations. So that will put it into next week before she would even have to say anything. And then once she's done that, I would then be able to set another date. So I'm going to assume that I have about 2 weeks before I can set another date to fully resolve the matter. Once the matter is fully resolved, that is, if I make a determination in your favor, Mr. Howe, she would then have 10 days to get out after that.
When was Miss Campbell served and how? By mail on May 14th, then personally on May 29th. Why does the method of service matter? Because it determines how many days she has to respond to the allegations against her, and that number changes everything about when the case can actually be resolved.
So that's the normal process for these kinds of cases. So she would have, because again, that's why I asked about the proof of service, because it makes a difference as to how long she has to respond.
An unlawful detainer proceeding, which is the legal term for a court-supervised eviction, is not simply the landlord saying, "Get out," and the judge agreeing. It is a structured legal process with mandatory timelines built in to protect both parties. When someone is served by mail with a notice to vacate, they typically have fewer days to respond than if they are served in person. In this case, the personal service on May 29th triggered a 21-day window for Miss Campbell to file a written answer, a formal legal response, to the claims against her. That 21-day period had not yet expired when the parties appeared in court on June 8th, which means the judge cannot set a trial date, let alone issue a ruling, until that window closes. Think about what that means practically. Mr. Howe showed up to court expecting resolution. He followed every procedural step.
So,
I mean, I'm fine with giving her as much, like at that point, that'll be roughly 60 days. So that should have been enough. She's got a mom, a dad that are willing to help her. She's got 5 siblings. I'm sleeping on my mom's couch here, and I'm about to have to pay for another residence. So it's like,
well, let me ask.
Yeah, I don't know what to do.
All right.
He served the notice. He filed the paperwork. He got the hearing date.
What I'm going to do is I'm going to set this matter for a hearing. Today is June 8th. My next available date that would be after her time frame for answering would be June 29th, or we could do it July 13th. Which you guys, the 29th, are both of you available on June 29th?
Yeah.
I will be.
All right, so I'm going to set it for June 29th. I have a previous hearing June 29th at 3:30, so I'm going to set this one for 4 o'clock.
And the judge had to tell him we are not there yet, because the proof of service, the documented confirmation that Miss Campbell was formally notified, was not in the court file. Mr. Howe had it. He just had not sent it in. That single missing document was the reason the judge could not move forward, and it is a perfect example of how people representing themselves in court get quietly derailed by procedural requirements they did not know existed.
Just one thing. You're saying documentation, that's just for proof of ownership for me. I don't know. I don't understand what she would need to bring in.
That's entirely up to her. I don't know what she would bring in either, but I wanted you both to be aware that I'm not responsible for bringing anything in. I'm the one that's making the decision. So if you want it, you need to bring it. Okay? You can't just say, well, I left it at home. If you left it at home, it's like it didn't happen.
It makes a difference as to how long she has to respond. That's why I asked. The judge is not being cruel here. He is being precise. And his precision is actually protecting Mr. How as much as Miss Campbell, because a judgment issued without proper verified service is a judgment that can be appealed, overturned, or challenged as a due process violation.
The only problem with Zoom is that if you want to use documents or pictures or those kinds of things, it's difficult unless you know how to screen share very well to do those things over Zoom.
Okay.
I will allow you, if you wish to do that, given the circumstances of today's previous hearing this morning. But I just wanted you to be aware of the problems with that sometimes.
Yeah, I think it might be better to do it in person then, Your Honor.
Due process, in plain terms, means that before a court takes action against you, the law requires that you be properly notified and given a fair chance to respond. Skip that step and the whole proceeding can unravel. The judge sets a new hearing dated June 29th at 4 p.m. He tells both parties to bring every document, every photo, every witness they intend to rely on.
All right. I will have, as is normal for most, or for all cases where it's in person, there will be a bailiff in the courtroom to make sure that parties remain civil at all times. So I'll set this for June 29th at 4 p.m. If you want to get here a few minutes ahead of time, the other hearing, if it doesn't go, I'll put you guys on even faster. If for some reason that previous one doesn't go, otherwise I'll see you at 4 o'clock on June 29th. That means that you are responsible for bringing any witnesses that you want to have here, and you're responsible for bringing any evidence or documents or pictures with you.
He makes it explicit if you leave something at home, it is as if it does not exist. Then something shifts. Mr. Howe mentions, almost as an aside, that he has not seen his 5 children in 30 days. That Miss Campbell is, in his words, holding them. The judge's response is immediate, illegally clean, that is a custody matter. This court cannot address it. You need a different proceeding for that. And the weight of that answer hangs in the air, because what Mr. Howe is really describing is not just an eviction dispute. It is a family coming apart in 2 different courtrooms at the same time, with no coordinated legal process to address both halves simultaneously.
She's
Well,
holding them.
I can't do anything about that in this court. That's friend of the court. That has to do with custody and parenting time.
Here is the broader legal reality this case illustrates. When an unmarried couple separates, they do not have the same automatic legal frameworks that divorce law provides. No marital property division, no presumptive custody arrangement, no unified proceeding that handles housing and children in the same forum. They are forced to pursue separate legal tracks. An unlawful detainer for the house, a family court action for the children, each with its own timeline, its own rules, and its own outcome that may or may not align with the other. The result is exactly what you see here, a man navigating 2 different courts simultaneously while sleeping on a couch, and a woman who is not breaking any law by staying in the house. Yet, because the legal process that would require her to leave has not run its course. That last part is what most people watching this kind of hearing get wrong. Miss Campbell is not a squatter in the criminal sense.
In circumstances, typically he would have the right to ask you to leave, Ms. Campbell, under the time frame that we just got done talking about. So you have the right 21 days after you're served to file an answer, that is a written response, if you wish. You're not required to. And then once you've had that time frame, then I can set this for a trial, that is a hearing in front of me, where he establishes that it's his house and that you're not legally allowed to stay there any further. That is, there's no lease, there's no agreements otherwise. And then once that occurs, you have 10 days to get.
She is an occupant whose right to remain is legally unresolved until the judge holds the trial, hears the evidence, and issues a determination. Even then, if the ruling goes against her, she gets 10 more days after that. That is not the system failing. That is the system doing exactly what it was designed to do, ensuring that no one is removed from housing without a fair hearing, even when the facts seem obvious, even when there is no lease, and even when the person asking them to leave owns the property outright. The lesson here cuts both directions. If you own property and someone lives there without a lease, your legal right to remove them is not instant. It moves through a process, and that process has mandatory timelines, mandatory documentation, and mandatory opportunities for the other party to respond. If you are on the other side, if you are the person without a lease, without a legal agreement, without a name on the title, understand that you do have procedural rights that the law protects. But those rights have an expiration date attached to a hearing that is coming regardless of whether you are ready. What you should walk away from this video knowing is simple and urgent. The moment you allow someone to live with you without a formal lease agreement, you have created a legal situation that cannot be resolved in a single phone call or a single argument. It will require a court. It will require documentation. It will require time you probably do not want to spend and money you probably do not want to pay. The law was built to protect people from being thrown out of their homes on someone's word alone. That protection is real, and it applies even when the homeowner is the one sleeping on a couch. Get the paperwork right the first time, because the only thing the judge cannot help you with is the document you forgot to file.